So I just filed another motion in my federal case. I have a civil suit against the criminals and the Colorado officials who protected them. And this has to do with Ann Kelly, Mike Gonzalez, and some other people. This here particularly is about Ann Kelly. Ann Kelly is the prosecutor for the 10th Judicial District, 12th or 10th, the SLV, whichever district is the SLV. I believe it's the 10th. And so she's the district attorney for the 10th Judicial District, and she did the exact same as all the other DAs did. They didn't care about the truth. They didn't care about justice. They just had a body, and so in their minds, their job is to just rubber stamp whatever the cops do. If a cop kidnaps a person, then that person gets totally screwed over. 60% of violent crimes don't get solved. So with that kind of mentality, 60% of violent crimes will not get solved by the courts or the judges or the prosecutors. If the cops don't catch the person and all they're doing is dependent on the cops and rubber stamping the cops, they're just letting the cops run hog wild while they put their head in the sand and just keep doubling down on this police state. So this is a partial summary judgment on the grand jury issue. This is a partial summary judgment on the grand jury issue, and then plus two appendixes, which I have the grand jury history and 25 SCOTUS created freedoms. And so my position is actually quite simple, to be honest with you. If you were just to read the Fifth Amendment of the U.S. Constitution, it says that you can't put a felony on a person unless you have a grand jury presentment or an indictment. It's got to go through the grand jury first. And so I'm calling that the grand jury right. As Americans, we all have a grand jury right. And the brilliance of it is actually, it's incredible. The genius, the intelligence that went behind the grand jury. The Fifth Amendment, the first clause, is that you cannot be convicted of an infamous capital or felony crime unless you've had 24 of your fellow countrymen that agree that you committed a felony. So it goes to the grand jury. You have 23 or 24. Sometimes you might even have 17. But as long as you can get 12 of the grand jurors out of, maybe even 12. As long as you can get 12 people up to 23 or 24 to do an indictment, then it goes to the normal process of prosecution, and then it goes to the petite jury. The petite jury is the jury that most people understand. It's the one that leads to the conviction, the sentencing, the punishment. But you have to go through the grand jury first. The grand jury is actually both a sword and a shield. So it's an investigative body. It's an inquisitional body. It's a bunch of folks, regular folks, you'd like to think, freemen, freeholders. And so knights, sometimes people try to get like the best members of the society or the district to sit on the grand jury. So you have a grand jury, and they can do it by presentment too. The grand jury, the prosecution leads the grand jury. The prosecution will say, here's a case, and here's the evidence, and here's what we think that this person did. And the grand jury could either agree or disagree. No true bill or file an indictment. Now the presentment thing is a little bit differently, but the presentment thing is grand jurors can bring charges up themselves. So if you are a part of the grand jury, you should absolutely think of yourself as somebody special in the community, because not only are you going to judge whether or not the prosecutor has a case, a felony case against, A, B, or C, but you could actually bring cases against anybody you want to. If you witnessed a crime, you can bring it to the grand jury, and if you get 12 grand jurors to agree to it, then that's a presentment. And a presentment is the grand jury essentially doing an indictment by themselves. So what's brilliant about that is that first you got to go through the grand jury. So 12 people, the grand jury has to think that there was probable cause that a crime was committed, and then it goes to the petite jury, and you need, you can only pick 12, and it's got to be unanimous. All 12 of 12 have to think that you committed the crime in question. And so that's the genius of the grand jury right. The American grand jury right says that nobody can go down for a felony unless 24 of their fellow peers within the vicinage, so 12 citizens, agree that a felony had been committed. So that's brilliant. That's absolutely brilliant. But a lot of people just skip over the grand jury. They go straight by information only, and then that's just tyranny. I mean, that's just fascist totalitarian tyranny. And so that's, that's essentially what I explain here. The Fifth Amendment to the U.S. Constitution guarantees an American, God, I always freaking mess up some sort of grammar in the very beginning. An American's right. The Fifth Amendment to the U.S. Constitution guarantees an American's right to a grand jury indictment for a felony accusation leveled at us. And then Colorado's Constitution says the same exact thing, only it's more clear-cut and dry. So America's Constitution says we have a right to a grand jury, indictment. And then the Colorado Constitution says we have a right to a grand jury indictment. And then if you use James Madison's double security, then that means you got 3 branches of 2 governments that should be upholding the grand jury right. That should be 6 branches of government upholding the grand jury right. So we declare for liberty, but in using the same word, we do not all mean the same thing. The shepherd drives the wolf from the sheep's throat, for which the sheep thanks the shepherd as his liberator, while the wolf denounces him for the same act as the destroyer of liberty, especially as the sheep was a black one. That's Abraham Lincoln address at Sanitary Fair in Baltimore, April 18th, 1864. So when the Confederates are talking about freedom, what were they talking about? The freedom to oppress another person? That's not freedom. The whole idea of rights is what's good for the goose is good for the gander. If I have a right to do something, you have a right to do something, And so that's how rights work. But there's some people that think freedom is you get to hurt other people all the livelong day. They get to do as they please. And then they get to do to you as they please. And that's what they think is freedom. That's not freedom, that's power. And they believe that their power is absolute, and absolute power corrupts absolutely. And so this partial summary judgment motion focuses on the grand jury issue. Appendix 1 is a short history of the grand jury in England and America. Since 1166, the grand jury has been with English law up until the colonization of America. And America continuously in every century without a gap, since colonization has had active grand jury proceedings. I also write on judicially created liberties and the incorporation process while maintaining that an average American ought to be able to read the Constitution and comprehend it. In 1871, when Section 1983 was passed, a remarkable 34 of 37 U.S. states protected the grand jury right. There's only 2 U.S. states which doesn't have the grand jury right today. So the grand jury is still active today in 48 of the states. And then when 1871 was passed, 34 of 37 states had protected the grand jury right. I'm going to say when it came to the Second Amendment, you only had like half of, like 20 something out of 37. And then when it came to the Eighth Amendment, it was like, right around the same thing, 34 of 37. So the Second Amendment was actually less. The Second Amendment was not as protected by the state constitutions as the grand jury right was protected in 1871. If SCOTUS had judicially created at least 25 freedoms, then why would we ignore any enumerated American freedom? That's such a good question. It's like we have an unwritten constitution, which the Supreme Court has come up with 25 other freedoms that we have. So we got this unwritten constitution that upholds 25, freedoms out of kind of the thin blue air. And yet they're not upholding the Fifth Amendment. Why wouldn't the venerated Bill of Rights be the law of the land? Why wouldn't the Constitution be the law of the land? Why are freedoms made up out of the thin blue air good current active law, but the civil liberties specifically written down in our short list of 10 are not? It's time to legalize the Constitution. Then I, kind of slowly but surely make my case, and I think it's a very good case, frankly. I just read some of the rules when it came to the stay. You have Noam v. Svitlana, 2025, and they're talking about on the application of a motion to stay. And then they were just saying how if it looks like the Supreme Court would rule in their favor, then you have to do the stay. The Supreme Court is going to go along with, the Supreme Court better. It seems like the Supreme Court would uphold the right to a grand jury. You had that Dobbs decision. I've read Dobbs through and through, and even though as a liberal, it sucks that they're saying that the right to an abortion isn't the law of the land anymore because it's not in the Constitution. But you know what is in the Constitution? The grand jury right. Our right to a grand jury. So, Ann Kelly maliciously prosecuted me, depriving me of my 2nd, 4th, 5th, 6th, 8th, 9th Amendment rights via the Due Process Clause of the 14th Amendment. So, I point out, and this is just one of, several complaints that I have with Ann Kelly, but she didn't hold a probable cause hearing. She didn't have a preliminary hearing or an evidentiary hearing. She definitely didn't convene a grand jury. So, the judicial system can't function on the caprices of a calumny. Hartman v. Moore, 2006, says that retaliatory prosecution is actionable if there's an accompanying absence of probable cause. There is an absence of probable cause here. No probable cause hearing, no evidentiary hearing, no grand jury preliminary hearing. They did none of those things. Ann Kelly went along with Alonzo Payne. Alonzo Payne was screwing over victims and defending the criminals. Ann Kelly did the exact same thing. All of these district attorneys did the same thing. And it's bullshit. So essentially, if you're kidnapped by the cops, don't think that anybody that's, part of the system, any of the officials are going to hear you out. They're not going to care about the truth. They're not going to listen to you. They're not going to uphold any of your rights. They're going to do anything and everything they can to fuck you the fuck over. Doesn't matter if you're an honest person. Doesn't matter if you're a moral person. Doesn't matter if you were lawful as hell. Doesn't matter if you spent a shit ton of money for a septic tank. It doesn't matter if you spent 1 year in Conejos County at an RV park wasting a bunch of fucking money so you would be compliant with the planning and zoning laws. It doesn't matter if you call 911. It doesn't matter if you are lawful as hell. And it doesn't matter if you're a victim of 200 crimes, by a handful of civilian criminals. So that's Hartman v. Moore, 2006, says that retaliatory prosecution is actionable if there's an accompanying absence of probable cause. Probable cause must be alleged and proven. Nixon did not have an absolute unqualified privilege because it's a categorical imperative to do justice in criminal prosecutions. That's the point of the whole damn system, is to do justice. To do justice is a function of the court. And that comes from U.S. v. Nixon, 1974. That's a famous case. U.S. v. Nixon, 1974, is going to force Nixon to resign. And what that was about was they had subpoenaed him to give up the tapes because they want to know about this break-in, this Watergate break-in. And he didn't want to give up the tapes. But to do justice in the judicial system is important. So if a subpoena tells the president that he's got some sort of evidence that's important for some sort of criminal prosecution, he's got to give that evidence up. Society, every man owes society the evidence that they have. This partial summary judgment needs only one fact, and it's this one. The prosecution commenced by Ann Kelly against John Masters in 2023 was by information only. That's 100% true. These lawyers, so it's interesting what these lawyers are doing, and it's interesting what Ann Kelly is doing. So you have Cruz Soto. He's got 2 lawyers. And the 2 lawyers want to know what is going on with the other 6 defendants that were, professionally served. We'll say professionally served. Because all these folks got, all the legal information via U.S. mail. I've also called them. I haven't put an ad in the paper, so maybe that'll be the next step, put an ad in the paper. So I don't think that's a bad idea. So put an ad in the paper, and then it's a legal notice, right? So we'll see which papers will carry a legal notice. So the summary judgment, the whole point of a summary judgment is this. If the facts are not in dispute, then the whole matter comes down to a question of law. Since it comes down to a question of law within the magistrate or judge, that's a perfect case for the magistrate or judge, because they just have to talk about the law. Now, they might try to say, that Ann Kelly did not try to prosecute me in 2023 by information only. They're lying a whole bunch of times. Christy Redmond and William O'Connell are not above lying. They're acting like there was a warrant. They're acting like that there was a warrant for my arrest or for a search warrant, which, led to the arrest of September 17th, 2021, which started all this. I fired 3 warning shots because I was being threatened. Somebody threatened my life while I was at home walking my dog. So not only did they threaten my life with a big industrial truck, but they were threatening my dogs, my property, and they were threatening me too. So the only question left that we have when it comes to the grand jury issue is a question of law. Because that fact cannot be denied. They might try to deny it, right? It was a warrantless arrest. So it was a warrantless arrest. And since it was a warrantless arrest, then that means them trying to assert that there was a warrant is a bunch of bosh. It's total bullshit. The other thing that they're trying to allege is they're trying to play this game because so far only Cruz Soto has these 2 lawyers. So what the hell is Ann Kelly even doing? So far, Ann Kelly, these folks right here, well, Cruz Soto has a lawyer, but these folks right here are just flat out saying, fuck you to the federal government. Ann Kelly says, to hell with you, federal government. I don't have to listen to you. I don't have to go through the process or the procedures. I don't have to file a damn answer. I don't have to do anything. I'm above the law. So they're flat out just skirting the federal court. Michelle Quintana, Keith Schultz, Nathan Rubal, and Danny Sanchez. I actually gave a sweet deal to Michelle Quintana. I had offered her, if she just gives me the transcripts, I would drop my case against her. And she said, no, I ain't going to do that. So that's stupid as shit. You were supposed to give me my fucking transcripts to begin with. And now, she's just going to make this case even worse. I'm suing all these people for $25,000 a piece. So Michelle Quintana, I guess she'd rather just give me $25,000. She'd rather just give me $25,000 instead of just giving me the transcripts like she should have done, fucking 4 years ago. It's incredible the way these people act. Danny Sanchez, and then, in a lesser capacity, Keith Schultz and Cruz Soto, I had paid them $200 or so to pass out some subpoenas. It's like Colin Romero. You paid her $400 to do a bullshit soil test. These people just like taking people's money, and they like taking people's money for no damn reason whatsoever. I also had paid $300 for the appeal. That fucking Roman Gilbert didn't give a shit about the appeal. And then I want to say there was something else, another thing when it came to some money that I had paid. I can't think. Oh, the transcripts cost $400 fucking dollars. So are they going to give me my $400 back? They, have this damn private corporation who you're supposed to go through them, fill out this paperwork, that paperwork, write down all the court dates and the times and the information. During the entire proceedings, the damn judge acted like not only was it being videotaped, or not only was there audio, which is what the transcription is, just a bunch of written words. So you don't actually get to see the body language with the audio. You don't get to hear the intonation, the tone of what was testified. You just read what was written. You just read what was said, which is horseshit. So you're going to pay $400 for a terrible transcription. I could have just brought in my phone and then recorded it and had a better damn transcription, a better evidence of the entire proceedings just by recording it on my phone. That would have been non-intrusive, but why would, you got to ask yourself questions. What kind of people wouldn't want their proceedings to be transparent? A bunch of corrupt criminals. That's the kind of people these motherfuckers are. So I paid $400 for the transcripts. Michelle Quintana is going to hold on to them. She hasn't given me the transcripts, isn't going to give me the transcripts, tells me to go to hell, right? So that fucks with my appeal. I'm supposed to do an appeal based upon just my memory. And then the appeal, I paid $300. That asshole said something like there was an order to show cause. And so basically he just made up some bullshit, didn't even apply it to law. Now, there is a little bit of a question there, which I'm still following up on that. But that's $300 Gilbert Roman owes me. That's $400 that Michelle Quintana owes me. And then it's $200 that Keith Schultz, Danny Sanchez, and Cruz Soto owe me. These motherfuckers don't mind stealing people's money. They don't mind taking people's money, and then when they don't do the job, they won't give the money back. That is stealing. I remember when I went to Velasquez in the very beginning, I paid Colin Romero. She didn't do her job, therefore she needs to pay me my money back. Velasquez, just give her the money. Just give her the money. Give her the money. She didn't do the fucking job, you dumb motherfucker. If I paid you $50, if you paid me $50 to mow your lawn and I took your money and I didn't mow your lawn, well then that means I owe you $50 or I stole that money from you. So these bastards are just such rotten criminal sons of bitches, it's not even funny. Let's carry on. So, with the Fourth Amendment violation of a wrongful and warrantless arrest initiated the entire process by skipping over the probable cause, evidentiary, preliminary, and grand jury hearings. How can you even know if you even have a good arrest without a probable cause hearing? They didn't, it makes me think of how many poor people and uneducated people are getting screwed over by this bullshit, system where they don't care about the justice. Have you ever heard of a lawyer saying, I'm going to do this in the name of justice? Oh yeah, because you're an officer of the court, right? So, let's see here. This opened the door for further violations, such as the abuse of process and Cruz Soto's Sixth Amendment violations. He didn't testify. Once the grand jury failed to return a true bill, then the proceedings would have ceased. They would have stopped right then and there. There wouldn't have been 27 appearances, no subpoenas, no violation of a speedy trial, no sequestration, no appeals, no certiorari. Ann Kelly suggested that I had sex with my witness. I mean, is that because Ann Kelly is having sex with Phil Greene? Is Cruz Soto having sex with Phil Greene? Is Danny Sanchez having sex with Phil Greene? Is that why Phil Greene and Sam Jepsen and Robert Pickerel are getting away with their crimes? Because Cruz Soto is just having sex with Robert Pickerel? Is that what's going on here? So it's okay to suggest such, ridiculousness for the district attorney. These are public officials, and these public officials are acting like a bunch of petulant children. A bunch of petulant children, who want to steal your candy, who want to steal your lunch money. An incident that leads to charges is sometimes described as a series of events because many times a one-time and a one-time only single crime doesn't happen out of a void without past or post events happening. This holds true for the criminal justice system. The line of demarcation between wrongful arrest and malicious prosecution cannot be maintained considering that arresting officers will need to testify at trial. Not having a judicial determination for probable cause is both a Fourth and Fifth Amendment violation. The holding of Gerstein v. Pugh, is that Pug or Pugh? We'll say the Gerstein decision of 1975 said that the Fourth Amendment requires a judicial determination of probable cause as a prerequisite to any extended restraint on liberty following an arrest. We Americans have our historic commitment to the rule of law. Yeah, right. This is nowhere more profoundly manifest, in our view, then the twofold aim of criminal justice is that guilt shall not escape or innocence suffer. Sam Jepsen took shots at me, so if firing a few warning shots in defense of the Second Amendment isn't being upheld, then how in the hell is it okay for Sam Jepsen to go to other people's house and drive around and flash their bright lights in the green blazer and then shoot at the person at their own home? How's that okay? How's that acceptable? Velasquez doesn't think a drive-by shooting matters. Cruz Soto thinks it's just fine and dandy to do a drive-by shooting. He don't seem to think that's a damn crime. Danny Sanchez, Ann Kelly, Michael Gonzalez, none of these motherfuckers think that they think it's okay for Sam Jepsen to do a drive-by shooting. It's okay for Phil Greene to commit crime after crime after crime, dozens of crimes, and even when he was called to testify, Ann Kelly protected him. So Ann Kelly is his best lawyer. Phil Greene's best lawyer is Ann Kelly, and since he suggested it, then that means it's fair game, it's fair play. You're allowed to suggest that the person is having sex with the witnesses. So clearly, Phil Greene must be having sex with all these people. So, I mean, if that's the way that I guess you get into power, you could sleep your way to the top. Good on Phil Greene, but Ann Kelly, disgusting. That's so wretched and disgusting. It's like she's got no ethical standards whatsoever. She has no morality, and she doesn't even understand the law. She doesn't even understand the law. And then she said that this is the summer of murder cases or murder court case. I forget how she said it. The summer of murder court cases. Because they got a bunch of trials coming up this summer about people that have shot and killed other people. So there is that King super shooter. He's going to get like 1,000 years in jail, something crazy like that. Not only did he get 10 to 20 lifetimes in jail, but he's also going to have 48 years tacked on for each and every attempted murder. So that means Sam Jepson should be looking at 48 years in jail. Robert Pickerel should be looking at 48 years in jail. Robert Pickerel was a passenger for a drive-by shooting, so he would be a key witness, a person of interest, and a suspect of a whole bunch more. He knows a bunch. If I'm a police officer, I definitely pull that person over and ask him a bunch of tough questions. But because I'm a citizen, I'm dependent on the police, I technically could make a citizen's arrest, but if they're going to freak out over a couple warning shots in defense of the Second Amendment in Article 2, Section 13, well, they're definitely going to freak out about a citizen's arrest. I'm just going to, go over there and put handcuffs on Robert Pickerel and then just throw him in my truck and then drive to the jail and then just drop him off at the jail and then, go ahead and file a warrantless affidavit, which is what they had done with me. It was a warrantless arrest. It was a warrantless arrest. And so for the lawyer to even suggest something that's just plainly not true, there was something else he had suggested too that just plainly wasn't true. I'll think of it later. So, a major reason to hold a probable cause, there's intelligence behind all of these proceedings. A major reason to hold a probable cause hearing is because one side could be bluffing with an accusation with the thinnest of pretense, if they have anything at all, while the other side could have all the evidence and all the legal backing in the world. So to not have a probable cause hearing, that just is stupid for the judge to do. That's stupid for the prosecutor to do. Why would you want to go through a whole bunch of crap when you don't even know if there was probable cause to begin with? You're going to go through a whole bunch of crap and you don't even know if there's probable cause in order to make the arrest. At least have the hearing to see if there was probable cause. And I'll explain Hurtado later on. But while the Fifth Amendment says you have a grand jury hearing, you must have a grand jury hearing, and that's to establish probable cause. There's other hearings you could have to establish probable cause. You could have a probable cause hearing. You could have an evidentiary hearing, and you could have a preliminary hearing. They did none of these things. They found a body, and then they want to abuse the body, and by information only, Annie Kelly is going to break Colorado Constitution, break Colorado law, break America law, break the American Constitution, break the Fifth Amendment because she's a criminal and she commits crimes against people that don't deserve it. She protects Phil Greene because she's a criminal. She also is protecting Sam Jepson because she's a criminal. They're criminals. Robert Pickerel's criminals. She protects the criminals. And that's even more disgusting when I even think about it. It sucked being harassed by those civilian criminals, but the official criminals are so much worse. The official criminals are so much worse. Whereas for 2 years, I lived in hell. It sucked having people just mess with me, and I had to run to the store and come back, go to the damn mailbox and come back real quick. This Colorado nightmare of these official proceedings, September 17th, 2021 is when the arrest had taken place. And then you're supposed to have a speedy trial. The trial doesn't happen until April 2023. So that was a year and a half later. And then it was a felony. They said felony menacing, which is if you try to scare somebody with a gun. I literally have videotape of a guy who just left Robert Pickerel's house, clicking his gun on the side of the white SUV. That was the first tape that I gave to Ann Kelly. I was so happy when she was elected. I was like, oh my God, I got this evidence. This crap has been happening to me. The damn judges and the other DAs and the other cops, they haven't been listening to the clerks. They haven't been listening to me. So finally we got a brand new eyes, a brand new set of, a mind. You would think it's a rational person. And so here's crimes caught on videotape. She's not convinced by videotape. Crimes that are caught on videotape. She's not convinced of it. But if somebody can produce a body, if somebody can kidnap a body, if some uniform with a badge and a hat can kidnap a body, well, then she knows that person is guilty, 200, 300% guilty. But if you have all the evidence in the world, well, she can't be convinced of it. How stupid. How stupid is she? She could issue warrants. She could issue search warrants. There's so many things that could be done if any of these assholes cared about the truth or justice. Law and order is dependent upon truth and justice is dependent upon the truth. So in a way, law and order and justice is all dependent upon the truth. So you would think that Ann E. Kelly would give a damn about the truth. But she does not. The truth does not matter to her. She don't care about the truth. Constitutional analysis must begin with the language of the instrument. That's Gibbons v. Ogden. Look at this. I am quoting from 1824. I am quoting American constitutional law from 1824. That's John Marshall. You would think any of these assholes, if they went to law school, if they passed the LSAT, if they weren't just a bunch of C and D students, maybe they just skated by law school, maybe they slept their way to the top, since we're just going to, use that suggestion for everybody. But if I'm a prosecutor of a district, I would be happy to have Mr. Rogers know the laws and obey the laws. The problem with Mr. Rogers being the only person who obeys the laws while nobody's obeying the laws when it comes to him, well, means that he's going to be, he's bounding himself to these, principles, and he's getting screwed the hell over while nobody else has to respect the laws when it comes to him. So the only person that gets screwed over in Ann E. Kelly's neighborhood are your Mr. Rogers who reads the laws. So why would that be? If you want to get down to the nitty-gritty of the thing, to the meat and potatoes, why would Ann Kelly be afraid of a Mr. Rogers who understands Colorado law? It's not my darkness they're afraid of, it's my light. She's basically the same age as me, and if I didn't have, tumultuous, childhood, and then my 20s, and then my 30s, it's been a rough ride. But essentially, let's presume I had, good supportive parents and people that were, backing me and championing me the entire way. Well, then, now I have a law degree. Now I could run, for prosecutor, and I would give her a run for her money. Because not only would I essentially have the same standing as she does when it comes to having a law degree, so therefore you're allowed to run for the DA, but I would understand human nature a lot better than she would. I would understand how to intermingle with the people. I would understand the freedoms and the rights that we all have. My God, I would be an incredible cop or prosecutor or judge. So it's not my darkness they're afraid of. They're afraid of their own darkness, but they're afraid of my light. And that's disgusting when you think about it even more. Because if you're a good police officer, if you're a good prosecutor or judge, you want everybody following the laws, and you want anybody who commits crimes to be thrown in jail. 60% of all the crimes don't get a conviction. 60% of all crimes aren't ever solved by the police or the prosecutors or the court system. And just with my own case, I would say 99% of all the violent crimes that had happened when I lived in Costilla County aren't being solved. 99% of them. And then with me firing a couple warning shots, that injured nobody. Joe Canty had testified that it didn't even give him an injury. The whole point is to stop one person from injuring another person. Meanwhile, my dog is dead. I got emotional distress, and then my day-to-day, I was a prisoner in my own home for a year. My day-to-day, daily work was, I definitely was injured. I had to change my entire schedule. I couldn't go, look for a wife or a career or do anything. I couldn't even build my fence. Phil Greeny's driving there, stomping on his, damn brakes like he's going to shoot at me. Every time I went outside to go work on my fence, it was like for a week, every time I went outside. And so if any of these cops, prosecutors, or judges, had presumed, maybe this guy's actually telling the truth. I called 911. You think criminals are calling 911? Robert Pickerel says, you're a cop caller. Okay, so what, snitches get stitches and body bags and ditches? That's, gang culture. That's gang culture. The reason why they knew me is because I was compliant with planning and zoning. I had called 911, and the reason why Cruz Soto arrested me was because he was sick and tired of me calling 911. I was a stranger to him. I was a strange man. I just came in to Costilla County, so he didn't grow up with me. He didn't know me like that. So since I was a stranger, I had called 911 too many times, and he was fucking sick of it. He was sick and tired of it. That's why Soto Cruz made the arrest. If you watch the video, they already decided to make the arrest to begin with. And then look at what evidence they have. What evidence do they have? I was in compliance with Second Amendment. The Second Amendment. So whatever, all they have is the words of Joe Canty. The video of Joe Canty just shows my truck driving, down the road, up the road, and I park in front of my property. And then the videotapes of the police officers just show me walk outside the house and talk to the cops. And then when they decided to arrest me, then, I asked if I could, sort of situate my household. And that's it. That's all that had happened. That's all the evidence that they have. That's the only tangible evidence that they have. So a liar can just spout off a lie, and then these bastards will double down and rubber stamp as if it's the God's honest truth, as if that's 300% true, and then deny videotape that just doesn't just show one felony. There's a whole bunch of arsons. There's a guy that's driving around my damn property. At the very least, that's menacing, felony menacing, right? That's harassment, menacing. What the hell is this person even doing? Stalking. You have arson after arson. You have the dead dog that was killed. You have these drive-by shootings. You got the 911 calls. What the hell are these people doing? The injustice that I feel about this whole situation is just absolutely repugnant. And then ask yourself this. I'm not going to presume that I'm guilty, because I'm not. I fired 3 warning shots straight up into the air because I was under threat. And it was proportional to the threat that I was faced with. Somebody said, well, it was an imminent threat. It wasn't an imminent threat. Well, you could do lethal force if it's an imminent threat. If it was an imminent threat, like within 1 or 2 seconds, then you're allowed to do lethal force. But it was about 5 or 6 seconds away. So 5 or 6 seconds away, it wasn't lethal, so my warning shots was commiserate to the threat that I was faced with. Does anybody doubt that a large industrial truck can't be used as a blunt force object? Does anybody doubt that? Felony menacing isn't just with a gun, but it also is with a knife or a blunt force object. So I'm going to come back to reading some more of this, but I'm going to point out, a lot of the Constitution. Before, when I was in Colorado, I was so inundated with Colorado law. Now I just, fuck Colorado law. Basically, they don't like people who are citizens who understand the law or have some understanding of the law. What they want to do is basically say, I know the laws. I went through the law schools. And since I'm the one that's in this chair, then that means you got to kiss my ass. And you got to listen to whatever bullshit I say, and then you got to kiss my ass. Just makes me think of the Fountainhead. Why did Peter Keating and Toohey want to screw over Howard Roark? Toohey says, we can make him obey. We'll make him obey. That was when Howard Roark got an indictment. We'll make him obey. And then Peter Keating goes, Toohey, don't say that. We'll make him obey. So they're trying to make Howard Roark obey. I'll come back with some more of this, but I just want to log at least, a little bit of what I had accomplished. This took me about, a week or so to write, and it just seems crystal clear to me, it just seems crystal clear to me. Because I believe the law says what it means and means what it says. That's a strict constructionist perspective and an originalist perspective. So in a way, me being conservative when it comes to my constitutional rights is actually me being progressive. I'm actually moving forward by going backwards 250 years. It just shows you how far backwards we've gone.